college admissions, affirmative action and admissions program, but affirmative action in K through 12 is not allowed on diversity grounds? Is that a fair way to summarize?
Well, I haven't read it, but it certainly sounds that way. And of course, one of the great distinctions between these cases and the higher education cases is that no one was excluded from a school. In the higher education affirmative action cases, there was a whole question about minority students taking the places of non-minority students, and the need to select certain types of students for those graduate programs. Of course, the undergraduate program was rejected. So this was a situation where no one was going to be excluded. The second is these were voluntary programs, as I said. No judge was ordering these programs, and they were supported by their communities. So we have a federalism, state rights issue. So all these forces were at work, and although certainly my impression from attending the oral argument was that there was not a strong push in the direction of upholding these plans, they were not easy to resolve given the state of the precedent before these decisions were handed down.
Pam Carlin?
Two very brief points, one of which has been alluded to. That is, these cases are, I think, the clearest example of an agenda-driven Supreme Court, because there was no conflict in the lower circuits. Usually those are the kinds of cases the court took. They denied the Massachusetts case that you referred to, in which Judge Boudin wrote the year before, when they had Justice O'Connor on the court. And it was after she left that the court agreed to take these two cases. The Sixth Circuit case, not only was there was no opinion from the Sixth Circuit. They simply affirmed the district court because they thought this was relatively clear. And it may be the worst litigated case ever to be won in the Supreme Court. The lawyer who litigated it filed a 9-page brief, and if you read the transcript, you will think you're reading Beckett. The second point I'll make about this is that this goes to a point that actually Justice Scalia was talking about in Grutter, which is the problem here is not that you can't have diversity in the schools. You can by citing schools in particular places and perhaps even by zoning. What these school districts tried to do was to do two things simultaneously, in the same way that Michigan wanted both diversity and the super-duper law school. These schools wanted both diversity in the schools and parental choice. And I think what is likely to have happened here is you can't do it that way. That is, by assigning or denying individual students the right to go to a particular public school. But you can do it by deciding to build the new school on the west side of town rather than the east side of town.